To be honest, I do suffer from bipolar disorder. I slip sometimes. I'm sorry. I do tend to self-medicate when I'm going through a hard time.
Let me stop you for just 1 second. Have you discussed with your psychiatrist your use of alcohol and THC?
Me and my team have agreed that I'm not going back to NA. I have been appealing.
Well, you didn't answer my question. What I want to know is, does your psychiatrist who prescribed you medication for bipolar disorder know with regard to your use of marijuana and alcohol? Yes or no?
Before we step into this courtroom, here's why this case stands out. It may look like a routine probation violation, but it's far more complicated. The defendant admits she has bipolar disorder, says she survived domestic violence, and confesses she turned to alcohol and marijuana instead of following her prescribed treatment. Those struggles are real, but the court must separate sympathy from legal responsibility. Judge Tepe keeps asking one critical question: did her psychiatrist know about her alcohol and THC use? That answer could shape the entire hearing. So what do you think? Should mental illness lead to more leniency, or should probation rules apply equally to everyone? Let us know in the comments.
Ms. Broders is present in court, out of custody. I have received a report from your probation officer that says that you have violated the terms of your ILC. Officer Nelson, could you read those allegations for me, please?
The allegations are the defendant violated ILC condition number 7 on October 14th, 2025, submitted to a drug test which was positive for marijuana and alcohol and admitted to use. On December 5th, 2025, submitted to an oral swab which was returned back from the lab confirmed positive for marijuana. And on February 17th, 2020, I think that's supposed to be 2026, but it says 2025, verbally admitted to using marijuana and drinking alcohol, was ordered to submit to a drug test, and left the office without testing.
All right, Ms. Broders, do you understand the allegations?
I do.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
I do not.
Do you want me to appoint you one?
No, it's okay.
You want to waive your right to counsel?
Yes, that's correct.
All right, there's 2 forms in front of you. The one that says waiver of counsel is the one you need to sign for me, please. All right, Ms. Broders, is that your signature?
It is.
Do you understand what this document says?
Yes.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No, Your Honor.
Are you under the influence today of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on today?
No.
All right, I'm going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I will accept that. Now, with regard to these allegations that Officer Nelson read, do you admit them?
Yes.
All right, the court's going to find that you have violated the terms of your ILC.
At this point, the legal issue is essentially settled. By admitting the violations, the defendant has removed the need for an evidentiary hearing, meaning the Judge Tepe no longer has to determine whether the violations happened. They already have that answer. Now the focus shifts to something just as important: why did they happen? And is this someone who can still succeed under court supervision? You'll also notice that she chose to waive her right to an attorney earlier in the hearing. That's a significant decision because speaking directly to the judge without legal representation can sometimes help demonstrate honesty, but it can also leave a defendant without guidance on how to present mitigating circumstances effectively. Everything she says from this point forward could influence how the judge views her credibility and her chances of receiving another opportunity instead of immediate sanctions.
To be honest, I do suffer from bipolar disorder. And at the same time that this case was ongoing, I have suffered from major domestic violence from the father of my children, strangulation and more. I've moved across the state of Ohio to Cleveland, alone. I slip sometimes. I'm sorry. I don't mean to get emotional. Sometimes the medication that is prescribed to me by my psychiatrist is not enough. I do tend to self-medicate when I'm going through a hard time.
Let me stop you for just 1 second. Have you discussed with your psychiatrist your use of alcohol and THC?
I have.
And he or she says what?
Me and my team have agreed that I'm not going back to NA. I have been appearing.
Well, you didn't answer my question. What I want to know is, does your psychiatrist who prescribes you medication for bipolar disorder know, or does he have an opinion with regard to your use of marijuana and alcohol? Yes or no? Does he know?
It is not recommended.
It's not recommended.
By her, no.
Her, okay.
This exchange may seem tough, but it's actually revealing exactly what concerns the court the most. The judge isn't debating whether bipolar disorder is real or whether life has been difficult. Instead, he's focusing on whether the treatment plan established by qualified medical professionals is actually being followed. When the defendant finally acknowledges that her psychiatrist did not recommend marijuana or alcohol, that changes the direction of the hearing. From the court's perspective, self-medicating isn't simply a personal choice. It can become a probation violation when it directly conflicts with treatment expectations and court orders. That's why the judge keeps bringing the conversation back to the same point instead of allowing it to drift toward unrelated explanations. What do you think? Should personal hardship reduce accountability for probation violations? Or should compliance always come first once someone is under court supervision? Share your thoughts below.
So I'm telling you right now that I have ordered you that you are not permitted to use it. Now, you're obviously not following your doctor's advice, because I've read the studies, and I am 99.9% certain that any legitimate psychiatrist or medical doctor would never prescribe the use of marijuana. They don't. The ones that do are quacks, and they're online. You are not allowed to use it. It's part of my order. Do you understand?
I do.
So here's what we're going to do. I am going to today continue you. I'm going to continue you on ILC. You actually should have been done with your case by now, but you, for some reason you're dragging your feet. I'm going to continue this. I'm going to continue you on ILC. I'm going to give you one more chance to get this right. Now, I'm going to set this for a review hearing in 90 days. In 90 days, you are ordered to appear in my court again, and you're to test today. You live where now?
I live in Cuyahoga County, sir.
So when you come back in 90 days, if you're still using marijuana, you're going to go into custody. Are we clear? Are we clear on this?
Yes, sir. I did want to say, Your Honor, I did already drug test today.
You did drug test today?
Yes.
And it was?
It will be positive for marijuana.
Okay.
However, I did stop smoking from my last
Okay,
drug
so
test.
90 days should be plenty of time for that to get out of your system. So you have 90 days to get this cleaned up, or you're going into custody, and I'm going to sanction you. You have no idea how the high levels of the concentrate of THC is affecting both your mental health and your substance use disorder. If you have bipolar and you're using marijuana, it is contraindicated. It is not healthy for you. I am trying to help you here by forcing you to stop using it. So you make a choice. Either you stop using on your own, or I can arrange so that you don't have access to it in the county jail. Your choice. So that's the order. You'll be back in 90 days for a review with me. But understand, if you're still positive, I'm taking you into custody. Do you understand me?
Yes, I understand.
All right, that's all.
Thank you.
This is a major turning point. Instead of sending the defendant directly into custody, the judge decides to continue her intervention in lieu of conviction program and gives her one final opportunity to get back into compliance. That's a significant break because the court had enough evidence to impose harsher consequences after multiple violations. But this second chance comes with extremely clear conditions: remain drug-free, comply with treatment, and return in 90 days prepared to prove meaningful progress. The judge also makes something very clear. this isn't an open-ended warning. He tells her that if she returns still testing positive, jail is the next step. Whether you agree with his approach or not, the expectations couldn't be more direct. The next hearing will determine whether this becomes a success story or ends with incarceration.
Ms. Broders,
Sir.
this is how you wish to proceed.
Yes, sir.
All right, Ms. Tranter.
Your Honor, these offenses occurred January 8th, 2026 in Warren County, state of Ohio. On that date, the defendant did by force, stealth, or deception trespass in an occupied structure or separately secured or occupied portion of that structure when another person other than her accomplice was present or likely to be present with the purpose to commit any criminal offense therein. She was also in possession of a scheduled substance, being heroin, in the amount of 0.52 grams, and also on that date in a separate residence did with purpose to deprive the owner of property, knowingly exerted control over that property without consent.
And principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on count one, the court will order you to serve a minimum term sentence of 4 years, maximum term sentence of 6 years. On count two, the court will order you to serve 12 months in prison to be served concurrent with count one. And on count four, 180 days in the Warren County Jail, that to be served concurrent with count 1 and 2 as well. You have 91 days jail time credit. The court's going to reserve jurisdiction with regard to the issue of restitution. Other than that, the court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Parole, which we spoke about a moment ago. Do you need me to go over that with you again?
No, sir.
This courtroom sequence highlights two very different outcomes, but both revolve around the same principle: accountability. In the probation hearing, the judge recognized the defendant's struggles with mental health and acknowledged that recovery isn't always straightforward. Even so, he concluded that repeated violations couldn't simply be ignored and chose to extend supervision while issuing one final warning instead of imposing immediate jail time. The message was unmistakable: follow the treatment plan, stay substance-free, and demonstrate real progress, or face custody at the next review. The second sentencing reminds us that negotiated plea agreements and agreed recommendations still result in substantial prison time when serious felony offenses are involved. The judge formally imposed a 4 to 6 year prison sentence, with the remaining counts running concurrently, while also addressing financial obligations and parole considerations according to law. Cases like these show how courts constantly balance compassion, rehabilitation, public safety, and personal responsibility. If you found this case as shocking as we did, make sure to hit the like button, share your thoughts in the comments, and subscribe Kazafi Says for more jaw-dropping courtroom breakdowns and real legal analysis.